for admission. Item number 1.
Hello, this PIL has been initiated challenging the procedure that has been adopted by the state government in public procurement
Why should
process.
it be a PIL? I don't understand.
Well, it's because we are not challenging a particular tender outcome. We are challenging a rules framed by the state government, Melats. It's in the public interest that the rule shall be reviewed under this PIL, Melats. Because the outcome of this rules that we are challenging is, my lords, that the capping of 5% is causing a direct loss to the public
There is
exchequer.
already a decision by this court long time back.
Multiple time, my lords. This 5% capping is not the first time. It has been initiated multiple time before.
So there are decisions of this court, no?
Yes, my lords.
Where is that? Is it here in
My
the
lord,
petition?
There is a difference between that and this. My lords, that time the judgment came that there was a capping of 5%, but the department was implementing that the rate shall be as per the prevailing SOR. So they were not giving a margin of 5% variation also that time. So the judgment was relevant to that aspect. So the outcome of the judgment was that the 5% as per the rules should be given the variation, not like prevailing rate of SOR should prevail. So that is a difference. Now we are challenging the 5% variation, my lords.
No, but estimates have to be made in terms of the SOR.
Definitely, my lords. The estimate is made, my lords, but the bidder should have the right to quote their own price, my lords. There should not be capping that you have to quote
5%.
up to 5%.
No, that's
otherwise
no.
you will be declared unresponsive.
So there is a judgment earlier by this court, long time back,
In the year
by a single
1992.
judge. Huh?
I think in the year 1992. But thereafter, my lord, there was another notification issued in the year 2005. I'll come to that when I argue, my lord. And this is not a rule, my lord. This is a notification which has been issued. It's a notification which has been issued,
No, just explain to me one thing.
my lord.
The schedule of rates made by the state government provides profit to the contractor at the rate of 10%, correct?
Absolutely.
My lord.
Now, if the contractor decides that he will be happy with a margin of profit of 1%, who are you to say otherwise? So why should you cap it at 5%?
No, my lord, there is a reason for that. I'll come to that when I make my submission.
And there's another aspect. You see, a schedule of rates pertains to even hiring charges of vehicles. Supposing for a certain contract, the concerned contractor has 1,000 trucks at his disposal or 100 trucks at his disposal. He doesn't need to hire. His cost will come down drastically because he doesn't need to hire vehicles. So, how do you justify that he should also make only this much? Supposing he says hiring charges is 2,000 rupees per load and he can do it at the rate of 500 rupees per load because the vehicles are his own. How will you justify that? No, you have to give your rates as per 2,000 rupees.
No, it's not exactly like that, my lord. My lord, the reason for the capping is this, my lord. The lower ceiling is intended to prevent abnormal lower rates, which ultimately results in poor quality of execution of works, escalation of price.
No,
and
that's all right.
ultimately loss to the
That's
state
all right.
exchequer, my lord.
Abnormal
And
lower
ultimately
rates.
loss to the state exchequer, my lord.
But if these abnormal lower rates are justified, if it is justified, then
No, sometimes, my lord, what happens? There are abnormal low rates which are unworkable. And we have the experience, the departments have the experience that in the middle of the execution of the work, there is a request for escalation of price, there is a request for revised estimate.
You're not answering the question. You see, you're not answering the question.
Lordship,
You see, when you do this road work, road construction, when you do building construction, most of the money goes on transportation. Now, like I said, if they can justify that they can do the work of transportation of a particular load or 1 ton or whatever at the rate of 500 and not as per the SOR of 2000, now what is wrong if it can be justified?
there is no wrong, my lord.
Then
What happens at the time of issuing the work order, they justify it. And ultimately, it's a practical experience, my lord, of departments. When we come to the practical execution of the work, the department has got the experience to see that midway they stop the work, they say that the rates are unworkable.
you
They
see,
say that we need to
for
submit
those
revised estimate.
you have got a contract agreement. This contract agreements made by all the major national, international companies also provides a clause where it has been stated oftentimes that if the contract is not completed by the contractor for reasons which are not justifiable or not accepted by the employer, then the work will be given to some other person and any extra cost that is borne would have to be paid by him. And in that way you don't even have to pay their bills.
My lord, that
And
ultimately,
performance guarantee is also forfeited, my lord.
my lord, that ultimately leads to litigations, and ultimately, my lord, it's a loss to the state exchequer. My lord, will kindly allow me to submit on the basis of my affidavit in opposition, on the basis
We
of
are
my
ready for disposal.
affidavit. My lord,
You want to dispose of this matter?
yes, my lord.
We are ready.
Yes, my lord.
We'll take it up after some time, then let us finish the others.
Lordship,
As you much, please.
as desired by Lordship.
Item number 2.
May I please, may I please, Your Lordship, I have some difficulties in my throat from yesterday, so
Okay.
I could not prepare. Let this matter be taken up next week.
Mr. Counsel, this case, where is your right? You are the second wife.
The children,
Yeah, just a minute. You don't have to say anything. Just keep it in mind. I will not dispose it off. But the fact of the matter is, you are the second wife. You are married as the second wife, which as per Hindu law is not allowed. You might have been married under you being you are a
Christian.
you're a Christian Nepali. You became a Christian during the subsistence of your marriage with your first wife. And as per the law of the land, as per the Hindu Marriage Act, first of all, you cannot have a second wife. And if there is any marriage during the subsistence of the first marriage, the second marriage is invalid, it is void, in fact. Number 2, as per the conduct rules, no person can have 2 wives. And there is a Supreme Court judgment in this case, I have it somewhere, that he was removed from service also. So how can you claim something? Supposing even if your husband had nominated you to get the pension, nomination in violation of the rules does not give you any right whatsoever. That is there in G.L. Bhatia's case, it is very clear. So I don't find any case. And the appellant seems to be correct. Single judge does not seem to be correct in that aspect. Because I think you just nod your head, yes or no. You were married during the subsistence of your first wife, correct? Yes or no? Yes or no? You say yes, and no. Don't give me that wrong shake of the head. Don't say yes. You have to say yes. You have to say
My
yes.
Lord, the whereabouts of the first wife is not known at the time of my marriage.
You started off very well, but started cracking now. Okay.
And my Lord, I would like to...
No, you see, whereabouts of the first wife may not be known.
My
But
Lord,
just because the whereabouts of the first wife is not known, does not mean that there has been a divorce.
even my Lord, the Dodarsan authority cannot contact her, and
Maybe
we are of the...
you see, under Section 107 of the Evidence Act, or Evidence Act, no? Just give me Evidence Act.
My Lord, she might have passed away, the first wife, so they are still trying to give the pension to her.
You see, the burden of proving death of a person known to be alive. It's 108. Burden of proving that the person is alive who has not been heard of 7 years is here. And then 107 is burden of proving death of a person. So, there is no case for you. Just because you cannot contact that person, you do not know where that your first wife is, does not mean that any right flows to you.
My Lord, if...
Day after tomorrow. Probably you will be well by day after tomorrow.
yeah, I hope so, but my Lord, if my condition is not improved...
If you are correct, we'll adjourn. If your condition does not improve, we'll adjourn. But you just keep that in mind. The law is very clear. A law is very clear. Nothing is in your favor.
I will make my
Look,
argument, my Lord. Because
Yes, no problem. You didn't have to come also. You could have told your junior. On the prayer of the counsel for the respondent, list the matter day after tomorrow.
Item number 3.
Please, Your Lordship.
This is for the first time it's coming.
Yes, Your Lordship.
So we'll issue notice.
Yes, Your Lordship. And this one Mulcon may call it TCR.
Is the trial going on?
Yes, Your Lordship.
Now why should we call this here? Why? For what purpose?
Yes, because Your Lordship, the grounds is violation of 47 and 48. So it will be needed.
No.
Maybe.
No. The trial court record not needed. Why should we delay the trial? Let the trial continue.
Yes, Your Lordship. It is continued.
Is there
Yes.
now? Let the trial continue.
Yes, Your Lordship.
Right. Your father?
I'm appearing on behalf of Mr. C. Zoram-sana, Special PPNIA.
Okay, right. Heard Mr.
Lalthang Moya.
Lalthangma, learned counsel for the appellant, who submits that the appellant's bail application number 62 of 2026 in NIA case number 05/2025 had been rejected by the learned special court, NIA, by order dated 22/6/2026. Issue notice to the respondent, Mr. Lal Vensanga, accept notice on behalf of Mr. C. Zoram-chana, Special PP NIA. You want to file written objection? You should file. They usually file.
We will be filing, yeah.
So how much time do you want?
2 weeks, if possible.
The NIA is granted 3 weeks time to file written objection to the application for bail. list the matter after 3 weeks.
19th of August. Item number 4.
May it please Your Lordship, I am appearing on behalf of the State Respondents. Your Lordship, on the 5th of June, there were directions given by this Honourable Court, which is enlisted in PAN number 4 to 7. Your Lordship, there was a direction to make guidelines for recovery of money, and there was a verification report to be submitted, Your Lordship. In this regard, Your Lordship, a verification was conducted between the 7th to the 9th of July 2026. Therefore, Your Lordship, consolidated report is being made, and as to
When was the verification made?
the verification, spot verification was conducted from the 7th to the 9th of July 2026, Your Lordship. And the report is yet to be issued. And as to the guidelines for recovery, Your Lordship, since this is this requires a cautious exercise, it is
What cautious? When they are not complying with the scheme, you have to take them back with interest.
Yes, Your Lordship. Therefore,
And there's one more thing.
yes, Your Lordship.
If it is found that they are not complying with the scheme, requirements of the scheme, like we have been told, we have been informed that one of the recipients, instead of having a garage, has got a workshop. If you can go drive to that place, I think you know who we are talking about.
Yes, Your Lordship.
If that be the case, why don't you close down that workshop? You've got to close down, otherwise we will close it down for you. When will you file that report?
Your Lordship, if I may be granted at least 3 weeks' time to
Why?
file the report.
Why? Report is, you just have to submit the report. You don't have to make any additions to the report.
Yes, Your Lordship. But since this is the guideline itself is taking time to frame, because it has to be vetted again by the LNJ department. So
No, but at least give us the report. For that you take some more time for the guidelines.
yes, Your Lordship.
But then for the report to submit, you can submit it within a week. We
Yes,
want
Your
to see, because we want to see the report and the action you have taken on those persons who are in the report and who have not made garages.
Yes, Your Lordship.
Like I said, we have heard that there is a workshop instead of a garage. What are you going to take? What are you going to do? And there's another aspect of the matter now. You see, while driving around, you will notice, is this AMC is there? AMC is represented?
Newly appointed.
A newly appointed AMC, okay. You see, Mr. Counsel, AMC has given this parking areas to a lot of persons. Now, some of these parking areas is making movement of traffic difficult. So, we know you need money, but not to that extent that you make life miserable for the others. Because in fact, your duties are in fact to make life easier for the citizens, not make it difficult. So, in those areas where movement of traffic becomes difficult, you should stop the parking. You should stop being made a parking area. Those particular areas. There is one, I believe, near the Greenwood, while coming down from Durtlang. You come down and there's a turn. After Greenwood, there's a turn. And in that turn, there's a parking. That's causing havoc.
But not only the parking, if I might add, Lordship, even the taxi stands. I'm sorry, I'm not sure if we should go in there, but even the taxi stands.
They should actually, but they should. Taxi stands are occupied.
Recently,
I mean, you and I, who have got normal cars,
Yes,
we don't have places to park.
yes.
Only taxi stand. You go to any other area, you go to Delhi, you won't find a taxi stand. You go to Calcutta, you see? So, I mean, even if they have, it is the majority of the vehicle owners in Aizawl or in Mizoram are not taxi owners.
Yes.
They are private car owners. and government. We also need space for parking.
And if I may add, my lord, recently the government of Mizoram, I think the government of Mizoram had come up with an app, like the Uber app. But apparently, it seems the taxi drivers are not willing because of some miscommunication, I think. So that also, that avenue also needs to be explored, man. I think the government
Yes,
also needs to explore these avenues properly.
No,
Because
you see, I think the taxi rates in Mizoram are the costliest in the whole of India. They have, from Zarkot to my house is 300. The other day a friend of mine came to my house, 300 rupees. From Zarkot to Chaltlang. When I was asking another friend, I asked him, is it normal? He said, yes, that's normal. I mean...
And also, my lord, I think once that app is operational, that will solve a lot of the taxi stand issues, because now they don't have to operate from one stand. Once they get the app, then they can run to that place and pick them up. So those issues can also be solved, my lord, to a certain extent.
No, those are policy matters. Why should we interfere?
Correct.
Those are policy matters. There's nothing for us to do. But anyway, madam, we need this report.
Yes, Your Lordship. If this matter may be fixed, Your Lordship, on the 5th.
Okay, 5th. By that time you
I
file
will
the report.
attempt. Yes, Your Lordship.
And you also tell us as to what action have you taken in respect of those persons who are not using their buildings as per your report.
Yes, Your Lordship.
It's like if you see a thief in front of you stealing something, you don't say that, let me carry on seeing what he's doing, let me enjoy the show. You'll do something, call the police, call neighbors or something like that.
Yes, Your Lordship.
So if they are doing things beyond the scheme, you cannot allow it to continue before your eyes.
Yes, Your Lordship.
Lordship, let me take the opportunity of this particular case, and I'm happy to deal with this matter. Lordship, the private school itself is also a big concern these days, so we may need to address someday.
That we'll take it up separately, because it will be expanding the scope of this. This is basically with regard to traffic. I understand that private schools are causing a lot of traffic jams.
Yes.
But then what to do? Unless the government says that no, schools should be located outside the Aizol or something, it becomes very difficult.
Proper arrangement, at least maybe in the internal, proper arrangement must be there. And some sort of parking lot may be reserved by the private school, or maybe hired.
You can tell your AMC bosses about it. Why should we? You tell them. You see, this thing is happening in Chaltlang. We've got so many now, this pre-nursery schools and what schools we've got. From around 7:45 to 9 o'clock, though, you cannot move. It's full of two-wheelers. Okay, right. Ms. Lalnundui, the learned government advocate, submits that in terms of the order dated 5/6/26,
Yes, Your Lordship.
the respondents have made a verification with regard to whether the beneficiaries of the PAHOS scheme, PAHOSS, PAHOS scheme, have utilized their buildings for parking, for public parking, in terms of the agreement executed by them with the government. Full stop. She prays for a week's time to file the said affidavit, said report. No, or should I put, you don't want it in your words, no? Or what? Should I direct you? You can do it
Yes,
with a week's time. Right. At the time of filing the report by the respondents, it should be clarified by the respondents as to the steps taken by them in respect of those persons who are mentioned in the report, who have not implemented the PAHO scheme in their buildings. Next paragraph. Ms. Lalnun Lui also submits, the government advocate submits, that the respondents need more time for making the guidelines for recovery of the grants given to the beneficiary under the PAHO scheme in respect of those beneficiaries who have not acted in terms of the said scheme. She submits that the guidelines would be made within
Your Lordship, if another 2 weeks time may be granted for the guidelines.
within another 3 weeks. First up, in view of the above, the Council for the State Government is granted 3 weeks time to submit the guidelines to be framed by the government for recovery of money from the beneficiaries of PAHOs, who have not acted in terms of the PAHOs scheme.
And Your Lordship, if I may add, there was also a direction to submit original agreement for sign between the beneficiaries and the government. If I may be allowed to produce those records within those same 3 weeks time, Your Lordship.
Okay. The state respondent shall also produce the original contract agreements within 3 weeks.
My lord, my appearance may kindly be reflected and
Just a minute, just a minute. Next. We have also been informed that there are many parking areas run by the AMC which is causing inconvenience to the movement of traffic and pedestrians within Aizawl city. This aspect of the matter would have to be looked into by the AMC and the traffic police. Accordingly, the SP Traffic, Aizawl, and the Commissioner AMC will constitute a team to verify, to make a report with regard to whether some of the parking areas within Aizawl city need to be removed to ensure free flow of traffic in that particular area. List the matter on 5th.
Obliged.
5/8. Huh? Little things, you see, because even in my locality, actually, it's very hard to pass 2 vehicles passing because the scooty 2-wheelers are there. When you go to that Mount Carmel, going up, just at the side of it, they are parking their 2-wheelers and AMC is merrily taking money. But we are having a hard time, passing that area. So everything is money for AMC maybe, but it has to be for the good of the citizens, no? Not for the good of AMC only. They are supposed to work for the people.
Much obliged, Your Lordship.
Item number 5.
Lordship, we were supposed to file objections.
No, in which one? In item?
Both these items,
No,
Lordship.
no, there are so many of them. Wait, item in IA 72.
Yes,
you-
Lordship.
that's you.
Yes, my lord.
You have not filed a written objection. How much time do you want?
My Lord, 2 weeks?
2 weeks.
Yes.
My lord,
Just 1 minute, one IA at a time.
Lordship, Learned Amicus has prayed time on 24/6/2026, and after that he had prayed another time in 2 consecutive court date, and this is the 3rd time after last chance, my lord.
You're lucky. If it was the government, they would have asked for another 2 years.
My lord, my permits expired on this coming December. Building permit,
So September,
December.
My Lord, he
December, my lord.
December. Oh, there's enough time. Enough time. And then now is the rainy season also.
and also
No,
he has not enclosed the permit on in his application.
Where is the?
No, I have enclosed, my lord.
He will go.
Yes.
It's not
Okay,
there.
no time. Anyway, we will give him time. Right. Mr. In the IS 72, huh? Mr.
Reuben.
Joseph L. Rensley, the learned counsel for the opposite party / petitioner. And just say opposite party. Is granted 3 weeks time to file an objection. This is the matter after 3 weeks. Then in the next, give me the next.
Obliged.
Yes, 465.
65, my lord. This is an
What do you want out here?
my lord. We have we are asking to allow us to continue the project
What project?
of complete street design that we have.
What is that?
undertaken.
What is that going to entail?
My lord, it's under SASKI scheme, and
What is it
this
going
is designed to promote pedestrianization and.
So you are going to make a pavement or what?
footpath, yes, my lord.
Okay.
Footpath
We
and
can allow that.
railings and public
We can allow
conveniences.
that. है ना, brother?
Yes, my lord.
They
Last
want to
chance
make
was
it
already given on 1/7/2026. Last chance for filing objection was
No,
given.
we'll allow it.
Ah.
I
What
think
objection can we give to this,
Yes,
my
my
Lord?
lord, that's why.
right.
It's
Heard in the IA 65. Heard Mrs. Linda L. Fumble, learned counsel for the applicants, and for the applicants, learned additional AG for the applicants, and Mr. Joseph L. Rensley, learned counsel for the opposite party number 1. Correct?
Yes.
Also heard Mr. Who else is there? T. Lalun Sema. Oh, we forgot to put his name in that other matter. You put Mr. T. Lalun Sema appears for the AMC. Mr. T. Lalun Sema for the AMC. Here also. The application by the state government is to allow them to continue the project of construction of complete street design from Bongkon to Dutlang Leitan under the SASKI scheme, part Roman 13, bracket 2025-2026. Full stop. She submits that the said scheme is designed to promote pedestrianization along the Bongkon and Dutlang Road by improving the footpath and public conveniences.
I think it should be conveniences, ma'am.
Conveniences.
Convenience, I think. Maybe the railings and
Ask Uncle Google what is conveniences. Conveniences, correct. Okay, conveniences. Okay, right, Which would also include landscaping and beautification. The counsels for the respondents submit that they do not have any serious objection to the application being allowed. On considering the submissions of the counsels for the parties and keeping in view that the issue pertains to promoting pedestrianization by improving the footpath and public conveniences along the said road, we allow the said application. The application is accordingly disposed of.
Obliged.
Then IA 122.
My Lord, same prayer like the previous one, like 2 weeks, my Lord, for this.
Okay.
Lordship, if I may, my building permit is already expired.
Then,
That will, if it's expired, then you ask for renewal.
All right,
You ask for renewal first.
all right,
But this has become infructuous.
okay.
You apply.
All right, all right.
There's no ground not to allow you.
Okay.
Okay, right. Heard Ms. Ruth Lalruat Feli, learned counsel for the applicant. Also heard Mr. Joseph Rinsley and Mr. Tilan Nusayama for the AMC. In view of the building permit
Building permit.
of the applicant having expired, the present application has become infructuous. The application is accordingly dismissed as infructuous.
obliged, Lordship.
Lordship, in the main case, I have found that as per the order 27.3, I am to file a affidavit stating some direction given by this honorable court. So it seems that I have not even filed a...
So you file it?
Yes, I'll
27.3,
27.3,
26.
2026, Lordship.
Right, Mr. T. Lal Nusayama, in the main case, Mr. T. Lal Nusayama is granted 3 weeks' time to file affidavit in terms of the order dated 27/3/26. Huh?
Para 17.
27/3/26 at para 17. Leaves the matter after 3 weeks.
Obliged, Lordship.
Item number 6.
May it please your Lordship. Lordship, I'm appearing on behalf of my senior, Mr. Johnny L. Tautsong. In this case, Lordship, notice is complete. However, my senior is absent today due to medical reasons.
Where is the affidavit of dusty service?
Lordship, in my file I have the affidavit. However,
Unfortunately, in my file I don't have it. Am I going to rely on your file? All your secrets, I'll have to look at it from there. You have not filed it. It's not here. No, we don't have, no? Affidavit of dusty service. No, we don't have.
Lordship, allow me 1 week's time to make the clarification and file if it's not yet filed yet.
It is not here. The
Lordship,
office
yes.
note would have reflected, and it is not here. See, this is the only affidavit here. What is your name?
Michael Patswell.
You are for whom?
The appellant.
You are for Mr. Mike. You are for, who is your senior?
Johnny L. Tautsong.
Okay, right. Mr. Michael Pacho, appearing on behalf of Mr. Johnny L. Tochong, learned counsel for the applicant/appellant, submits that he will clarify whether affidavit of dusty service has been filed by the applicant, inasmuch as the office note does not indicate filing of the said affidavit. Leaves the matter on.
After 1 week, Lordship.
Give a date.
5th of April, 5th of August.
Much obliged.
Item number 7.
My Lord, in item 7, the respondent number 2 has been served a copy of the notice, my Lord. And it has come.
How long will you take?
Well, let's maybe 15-20 minutes. 15 minutes maybe.
There is one aspect of the matter. Whether this PIL is maintainable.
My lords, if we would have challenged any particular outcome of a tender, then, my lords, it's absolutely correct, this PIL is not applicable. My lord, this PIL challenges the rules framed by the state government. It's not about we are challenging a particular outcome of a tender. my
When
lords.
do you file a PIL?
When there is a public interest is involved, my lords. In this case, how the public interest is involved, because, my lords, the 5% capping is causing a substantial loss to the public exchequer.
That is a different issue, Mr. Counsel. That's a different issue. PIL, what does the Supreme Court say with regard to filing of PILs? Do you have the latest judgments? Do you have the judgment? What is the object of filing PIL usually?
Well, the object is something to be related to public interest, and with the outcome of the PIL, a public interest should have been resolved, my lords.
I think that issue, you see, the issue that you all are bringing about, no doubt it's a germane issue, but we are not sure whether it can be, the manner in which you are challenging it can be done by way of a PIL.
Well, that's because we are unrelated to any tender.
You may be unrelated, but this is a business issue. This is a problem with contract matter. It's not a.
My lord, it might be the contract matter, but, my lord, the work given through a contract is related to public work, my lords.
एक मिनट वो देखो हाँ ले जाओ I'm not sure that this matter can be heard in a PIL.
My lord, if
You'll have to address that issue first. Not on the merits of the subject matter here. The issue as to whether a PIL can be entertained in respect of a contract matter, where a particular notification has been challenged.
My lord, the contract matter pertains
And
to a
also,
public
my
work.
lord, this matter is a policy decision of the government.
I doubt. You address me on that. Show me citations on how this will be maintainable.
My lords, today I am not well prepared for this issue. My lord may give another date. I'll address the same issue, my lords.
Yes, Mr. Deb, what to do?
Ready to argue because, my lord, the main problem is most of the government works, the development works had to be stopped.
Why?
Due to an interim
my
order
lords,
which has been
absolutely incorrect.
There's no stay order.
No, my lords.
Yes, my lord, there is an interim
My
order.
lords, there is a...
And we cannot execute the works.
No,
We cannot go ahead with the works.
there is no stay order, Mr. Counsel. There is no stay order, Mr. AG. There is no stay order. You can continue with whatever. But there is a thing, you see.
No, my lord, there is
without going into the issue of whether this PIL is maintainable, the issue brought out by him is very relevant. And I think maybe you all will have to go through it. But I am only on the issue of whether we can take up such type of matters in a PIL. That's what I'm concerned.
Lordship is absolutely right.
So you'll have to, because I think Supreme Court has clarified what types of matters may be taken up in a PIL.
And moreover, my lord, the government has taken this decision. It is a policy matter of the government. And on merits, I am ready to argue the matter, based on the Supreme Court judgments.
Let's if the other side has no objection with respect to the PIL issue, we can go on the merit and
No,
decide.
no,
the
just because you two are agreeable doesn't mean that I have to agree with
I
you.
completely bow down to that.
What is that?
My lord, I'll definitely issue this, address this issue, but
Because
my lord, I
once
was
we
not
take
well
our
prepared.
That is the
it's going
first
to be
issue.
binding.
Today I was not well prepared to address this issue, my lord, but for the next hearing, I'll definitely address this prior to going on merits, my lords.
Okay, when?
My
As
lord,
per
it
the
may
date,
be
my-
recorded.
Huh?
It may be recorded that the learned counsel for the petitioner shall have to address the issue of maintainability first. It may be
Yes, yes.
recorded in the order, my lord.
Yes.
And the government, the departments can go ahead with the contract works.
There is no bar, Mr. AG,
My
there
lord,
is no bar.
My lord, there is an interim order, my lord.
There is interim order.
My lord, there is a
Yes, my lord.
interim order, my lord, that is with respect to implementation of this 5% notification, and the SBD would give arbitrary power to the state authority to pick and choose any person as per their whims, my lords.
We are proceeding with this 5% and 10% capping, my lord.
My lords,
That is the policy. decision
prior
of
to
the
this also,
government.
CPWD manual has been addressed to and has been incorporated by all the departments in in Mizoram state, my lords. As per the interim order, it only state that till the time this dispute is resolved, prior to this
How can you
CPWD.
stop development works, Mr.
My lords,
Counsel?
there is no hampering of the development work, my lords.
Yes,
The
my lord.
interim stay only pertains to new tender.
Hey, what do you think new tender is for?
My lord, whatever it is, we are just of the apprehension that this 5% rule and the arbitrary power to select among the bidder has been stayed as per the interim order, my lords. Now the state government is actively,
We'll list it when?
my lords, any day beyond this week, my lords.
My lord, 13th of August, my lord.
13th
I'll come
of-
physically and argue the matter.
Okay, right. On the prayer,
Lordship, in the meantime, Lordship, my humble prayer, my lord, my most respectful submission, my lord. In the meantime, the government may be allowed to, departments may be allowed to proceed with the works.
there is a stay order, you have to complete the thing. It does not look nice now. If you are going to, we'll give you a short date if you want.
And the interim stay also, my lord, my lord, the interim
There
stay.
is a stay order passed, unless you have
Yes,
to
my
ask for
lord.
vacation also.
Again, that is a outcome of this PIL, my lord. If the PIL is not maintainable, how the stay order can be maintainable, my lord?
That is going to be decided. I don't know whether this PIL can be done on this kind of matter. They're telling the notification. And that's all. Now, see, now this, I don't know, notification of contract matter, whether, in a contract matter, whether they can challenge the notification by way of PIL. And he has got no interest in the thing also. You have got no interest, you are not a contractor.
Sorry, my lords?
Are you a contractor?
No, my lords,
You are
absolutely
not a
not.
contractor, then.
My lord,
where
that is
their
the
interest?
reason why it has gone through PIL, my lord, because the public
Has
interest
it
is
gone
involved.
through the PIL cell?
How are you?
About me,
No, this petition.
sorry, my lords, I'm not able to get.
There is a PIL cell.
Yeah, it has gone through that, my lord.
Huh? It's gone through that?
Registry might be knowing that, my lord.
No, it's not gone.
Ma'am, my lord, we have filed the PIL as per the proper procedure, my lords.
Whenever the PIL is filed, it has to go through the PIL cell. But that is for the principal seat, not for here. But I don't know whether this case is maintainable. Next date. You want a shorter date, I can give you a shorter date, whenever you want.
Let me take it up on Friday then. Day after tomorrow, I have to do it
My
today.
lords, I have to address a very pertinent issue, my lords. May at least give me any date from the next week onwards, my lords, not this week.
Friday might be a slight problem. My brother will also have to go in the. Oh no, you're staying. He is having a problem.
My lords, because I have to address a new issue here, so some days may be given. Any date from the next week onwards, my lords. I have no issue in the next week also, my lords.
Yes, we'll fix a date. When do you want, Mr. AG? Leave it up to you.
Then 5th of August, my lord.
Okay. On 5th of August. Who is there next week? Okay. Okay, we'll fix it on 13th better. He wants it on 13th. On the
13th, but my lord, in the meantime, the departments may be allowed to proceed with their works, my lord.
My lords, there is
is there any
everything has been stopped.
No.
All the development works have been stopped.
No, my lords, it's absolutely wrong to say that any work has been stopped, my lords.
Most of the departments,
My lords, the only
instructions. Lordship, I am submitting on instructions. We are unable to proceed with the works. And if this PIL is not maintainable, this interim order is also the outcome of this PIL, my lord.
Impugn notification. What is this SBDs? What do you mean by SBDs?
My lords, after this 5% notification, it limits the variation how much it can be quoted. My lords, thereafter,
What is the full form of SBD?
Standard bidding document.
That's all I wanted to know.
So, my lords, in the standard bidding document that has been issued by the state government, what they have done, first they have raised a capping of 5%. My lords, all the bidder will quote everybody want to be L1, they will quote 5% lower. Then, my lord, they have issued a SBD which states that if there are multiple L1, we will arbitrarily pick and choose and decide whom to give the work. That is also under challenge in this PIL, my lords. And my lords may also note the way the rule has been incorporated. May I show to your lordship, my lords?
No. First on the issue of maintainability.
My lords, I'll address that. But my lords, the interim stay is not hampering any work. It only states that this notification should not be incorporated in the terms of tender. My lords, can float the tender. Even before this notification, also many tenders have been floated throughout multiple decades, my lords. We are only with the issue with this notification as well as arbitrary method to decide whom to award the work. That is incorporated in the SBD.
You give a list of the tenders or NITs that are kept in abeyance.
Absolutely. That will address it.
Can you show me, can you give me a list? Mr. AG,
Lordship,
can you give me a list of all the NITs that have been kept in abeyance?
my learned additional AG, Miss Linda Pambal, I will request her to submit that list. She has the instructions.
Yes, what are the NITs which are kept in abeyance?
Even where there is a single tender, even in the education department, there is an instance of a single tender. There has been several IAs have been filed, my lord. Several IAs have been filed just to allow the departments to proceed with the works. Even in a single tender, my lord, a single tender, that work also could not be executed.
We were supposed to file an IA.
We have kept it on
for
hold.
one of the departments, but since we are of the view that the other side will take time, so we have not filed yet. It's from the higher and technical department, my lord. We have not filed it yet. It's already ready.
So you filed the affidavit? For what? Regarding what?
IA, for allowing to continue us to work, for the work.
What do you mean? The work has stopped?
Stop, my lord.
No, not stopped again.
No, all works that are,
No, no.
all works are stopped or what? What is it? I don't think it's correct.
That cannot be, my lords.
Only a tender process has stopped.
My
My
lord,
lord, tender process.
My lord,
If
not-
the tender process has stopped, my lord, we cannot undertake the development works.
my lords, no tender
That is-
process has
that
been
is as
stopped.
simple as that.
Only the terms has to be
As simple as
amended that this 5% capping cannot be incorporated.
My lord,
We are
even in
not hampering any
2007
tender progress, my lords.
My lord, I'll show your lordship. Even in 2007, if my lord kindly comes to my affidavit, page 26A, my lord, if I can kindly take your lordship. Page,
Anyway, I think you all have the hearing, that will be fixed, you all have the hearing. But only on the maintainability first.
I'll address that issue, my lords.
On the prayer of Mr. Karthik Jain, learned counsel for the petitioner, list the matter on 13th August for admission hearing, wherein the issue of maintainability of the petition, PIL, will also be considered.
Obliged, my lords.
lordship, in the meantime, can we proceed with the works?
No, there is a stay order.
Actually, my lord, in case.
You
I'm
see,
giving-
if there is
I'm
the
giving your
works,
lordship a single instance. Just one instance, my lord. In the education department, there's a single bidder.
there's
A fresh
single
tender
bidder.
was outed, and there's a single bidder, my lord.
Wherever
And-
there are single bidders, so we will allow. But no, it depends. Wherever there are single bidders, wherever the bid, if the bids of the tenderers are different, wherever the bids of the tenderers are different, then those can continue.
And my lords, if there is a single bidder,
For
there is
that
no
purpose,
issue of 5%
we need
capping
to
also.
file the IA.
You see,
Do we
where
need to file an IA,
there is a single bidder,
Madam.
you continue.
No, no.
My lord, that can be recorded in the order, my lord. If your lordship kindly.
No, single bidder. But then again, the issue is whether
Single
they will-
bidder.
They will give on the single bid. That's
My lords, that has to be decided as per the laws because the single bidder has
Wait
to
a
be
minute,
analyzed.
just a minute, please keep quiet.
Understood. Apologies, my lords.
There's a certain limit that we
I
have
apologize.
patience.
I apologize.
Yeah, certain limit to our patience. Don't have to interject every time there is a certain issue. List the matter on 13th. 13th August is what date?
Friday, my lord.
Friday. Thursday.
Thursday.
You want it on 11th? We can do it on 11th also. Or 10th also.
My lord, I'll be, actually I have some personal problems, my lord, that is why I'm reaching Aizawl on 12th.
Okay, 13th.
If my lord can kindly accommodate.
Okay, 13th.
Obliged.
And in the meantime, my lord, in case of single bidder, we can proceed.
We don't need to say that. You carry on.
At least there might be some problem later on.
You
my lord,
see,
when
we don't want to
kindly-
make
kindly-
any
kindly make an
comment.
observation.
We don't want to make any comment on single bid because to give a tender on the basis of single bid also might not be proper at times. So because even the state government, I think the other day, they had not awarded the tender because there was only a single bid. So that we leave it entirely up to you.
Lordship. Much obliged, my lord.
With the Lordship permission, may I mention, Lords, I am filing 2 criminal appeals.
Huh?
I am seeking listing of 2 criminal appeals which I am filing today, my Lord. These are the 2 other connected matters which were listed before the Lordship yesterday, where Mr. Sehgal requested, my Lords, and are kept tomorrow. I am today, my Lords, filing 2 criminal appeals. They are in the registry, my Lords. Because it's so voluminous, my Lord, taking some time to number, my Lords. My Lords may permit the listing for tomorrow, my Lords. The other 2 appeals also. I am grateful.
Have you filed it?
My Lords, we are in the registry, my Lords, already.
Huh?
We are already in the registry with the entire filing.
Okay.
I am grateful. Deeply obliged.
May I please your Lordship? Lordship, with the consent from the other side, I beg to mention item number 2. As my senior Mr. S.K. Medhi has some part-heard matter before Honorable Chief Justice Court. Lordship, if possible, matter may be taken up on tomorrow. Lord.
Tomorrow we have got too many matters. Tomorrow is
Day
full.
after tomorrow?
Okay, list the matter day after tomorrow. On the prayer of the counsel for the appellant.
I seek your Lordship's indulgence in mentioning item number 12 and 18 of part 2, my Lord.
Yes.
My Lord, with the consent of the other party, if the matter be taken up next week.
Okay, on the prayer of the counsel for the petitioner.
Yes, my Lord. Appellant in item number 12.
On the prayer of the counsel for the appellant, list the matter in the next week. Item number 18 is, what are you?
I'm for the respondent number 1 in 18.
In the respondent number 1 in item 18.
Obliged, my Lord.
Item number 1.
May it please your Lordship. My Lord, by filing the instant arbitration appeal, we are challenging the order which was passed by the learned additional district and sessions judge in arbitration petition application number 4 of 2024, wherein the application filed by the instant appellant was dismissed on the ground that, my Lord, during the arbitral proceedings, the representative of the appellant had apparently submitted that they had no objection, and that is why the application under section 24 was dismissed. And my Lord, the brief facts is that, my Lord, and as per the direction of this Honorable Court, I have placed the first award, which was given in favor of the respondent number 1 here in my Lord. I have
come to the point. What is your issue? You are going here, there.
My Lord,
what is the issue?
My Lord, the main issue is that the respondent number 1 was initially given an award for value of his assets, crops.
For his crops?
Yes.
Compensation for crops?
Crops, yes. The amount of rupees 12,72,000.
Then what happened?
Then thereafter he has filed an application before the arbitrator, and then the arbitrator
took up the matter.
Yes, arbitrator had awarded a further amount of rupees 55,53,873.
55 lakhs?
Yes.
For what?
For damage to crops.
For damage to crops?
Yes.
55 lakhs?
Yes. And if your Lordship will see, I have placed the order dated 03 September 2021.
There is one petitioner.
Yes.
I mean the landowner is one landowner.
My Lord,
what is?
In this particular case, only one.
So
yes.
For him, how much was the increase in the crop?
Increase amount is 55 lakhs, 53,000.
55 lakhs for him only?
Yes. So the total amount with the initial 12 lakhs something, it comes to 68 lakhs, 26,353. Total amount payable to the respondent number 1. And that also, my Lord, with respect to only one land. Only one.
And which is that land? Let us see. Which is that land?
My Lord, it is at page number 33. Page number 33. This is a VC house pass.
A VC house pass?
Yes, VC house pass.
For a VC house pass, they are giving crop compensation Of 67 lakhs, my God.
68 lakhs.
68 lakhs.
68 plus.
Okay, leaving that aside,
My lord.
that is not our concern.
My lord.
Because that is the question of fact.
My lord.
Now, so you are challenging the arbitral award.
My lord.
On what ground?
My lord, on the ground that reassessment was made for this additional 55 lakhs 53,000, and during the proceedings before the
reassessment made by whom?
By Kala.
By Kala.
Yes.
Then by Kala then.
And then, however, in the arbitral.
By Kala? How can Kala?
Yes.
But Kala.
Yes. And
then,
however, we were not given any opportunity to examine the surveyor.
What examine? Cross-examine.
Yes, cross-examine.
Please use the right word. That's why it gets
lord.
confusing. To cross-examine the surveyor who made the
Exactly,
report.
my lord. Exactly.
See that.
We have not given that opportunity.
You see, you've got to choose your words carefully.
My lord.
You see, the correct word has to be used. There's a difference between examine and cross-examine.
My lord. That is basically our case, my lord, why we have filed the instant.
Then you went in, and so you went in section 34.
Yes, section 34.
Now section 34 was dismissed on the ground that?
On the ground that during the arbitral proceedings, the representative of the appellant had apparently said that they had no objection. That was recorded. And that is why the whole section 34...
Where is that? Page?
My lord, at page 43. The arbitrator award it starts from page number 38.
No. Where is the portion where you have not objected?
My lord, page number 42, paragraph 5, last line. Page number 42, paragraph 5, last line. Representatives of NHIDCL also not object the complaint.
Object the complaint?
Yes. That is a wording.
So there's nothing which says that there's nothing with regard to the surveyor's report. It's with regard to a complaint.
My lord. Even it was even recorded that reassessment for the said portion has been conducted on 14/10/2021, assessment copy of which was issued to the applicant as applied. Yes.
Who is this arbitrator? Arbitrators are...
My lord, arbitrator name is reflected at page number 38.
Dr. Lal Rozara. Property asset value damage, rearing house. So what is the stand you have taken in this appeal?
My lord,
that you did not make any objection?
Yes, my lord.
Where have you stated that?
My lord, on the grounds, it starts from page... I will take your lordship at page number 16. Page number 16. From the 6th line. In fact, the statement made by Kalam were not based on evidence and subject to cross-examination from parties in this regard. Submitted arbitrator could not have passed a word solely based on statement without the same being let into evidence. It may be further stated herein that the said surveyor who purportedly conducted...
Mr. Counsel.
Yes, my lord.
The issue is very small.
My lord.
Where have you stated that this line at page 42 is wrong?
My lord, It starts from page number 12, paragraph 6.
Mr. Counsel, just
Yes.
come to page 42, come to this para 5, the last line. What
My
does
lord,
it say?
my lord.
Last sentence, what does it say, page 42?
Representatives of NHLDCL also not object the complaint. That we have stated
Where?
at para 6, page number 12. Page number 12. Para 6. If I may read.
Okay. This is what I wanted.
My lord.
Please understand the question, don't jump.
My lord.
Please understand what we want.
My lord.
We have given you specifics. Now, only the third time now, after the third question, the third query made by us, that we have gone to this page. Yes.
Yes, my lord. Actually, their grounds of appeal start from page number 15 and in their main grounds of appeal. That
No, the simple thing is,
yes,
you see, they have said that they have not been allowed to cross-examine the surveyor.
Lordship, with regard to that, they are giving, they are providing an opportunity of being heard when proceedings was before the landed arbitrator. All the representatives were present. They are given opportunity of being heard and also rebut, Lordship. A hearing was conducted on September 5, 2023.
Hearing conducted by the arbitrator?
Yes.
On?
5th September 2023.
September 2023, huh?
Yes. And during that time, on behalf of the appellant NHIDCL, Abhishek Singh, engineer PMU, was presented, Lordship.
As surveyor's report is dated?
Surveyor report is dated 14/10/2021.
14/10/2021.
Yes, that is the reassessment. Lordship, actually, this appeal is arising out from that application under section 54 before the additional district and session court at Champhai. Actually, in that their application before the additional district and session judge, they did not make any single grounds for that surveyor was not summoned for cross-examination, so and so. In their application before the district and session judge.
No. How many times did you appear before the arbitrator? Once?
Yes, Lordship, once. However,
where is your prayer to the arbitrator that you wanted to cross-examine the surveyor?
Yes, Lordship, they did not make any prayer with regard to that. And
where is your prayer?
My lord, we have not made a prayer on the ground that we want to make. However, we have
Lordship, if I may take you into page number 42 of their appeal petition.
42?
Yes.
Yes.
That particular ground, my lord, that has not been taken as a ground.
42, that the appellant also already mentioned in the last, para 5, last line, representative of NHIDL also not
however
the complaint. And beside, Lordship, page number 47 at para 9. If I may read out, Lordship. Page number 47, mark as para 9. In that para, Lordship, it is very clear that the representative of NHIDCL had, engineer of the representative of NHIDCL had no objection with regard to our complaint. And beside that, Lordship, they clearly mentioned that I am entitled with regard to the reassessment. That submission was clearly made by NHIDCL representative. And beside, Lordship, when they made application under section 34 before the additional district and session judge,
how big is their land?
Lordship, with regard to that, I will come to.
Anyway, leaving that aside, That is not the issue here.
Yes.
Now, so why did the learned trial court, why did the district court dismiss your appeal?
My lord, basically because in the arbitration proceedings.
No, where has it been stated? Forget arbitration. Where is the order? Let us see the order.
Yes, my lord.
Where? What does it say?
My lord, this starts at page number 1, right after the index. Page number. It starts from page number 1. Order. The 5th paragraph, the most bulky one, if I may read. Before entering into the merit of the case as submitted by the learned counsel for the respondent number 1, it is found that the impugned award dated so and so at para 9 has clearly mentioned that representatives and engineer concerned is present in respect of NHIDCL has no objection while this arbitration case was heard. Hence, as was held by the so and so, then my lord, that dismissed. However, my lord, my learned friend had stated that before the while filing Section 34 application before the District and Sessions Judge Champai, we have not taken the ground that the surveyor was not cross-examined. However, we have taken a ground, if your lordship could kindly come at page number 63, ground number 1. We have stated that page number 63. Page number 63,
yes.
A. That the impugned awards are perverse and unjust in as much as it allows some of the claims of respondents without any basis on law and or facts or evidence. That part we have taken as a ground, that no evidence was adduced. That we have taken a ground, however, we have not specifically mentioned that the surveyor should have been brought and cross-examined. That, and if your lordship will come again at page number 47, which my learned friend had relied at para number 9. What was examined before the in the arbitration proceedings, my lord, this is only the report of Kala. Only the report of the Kala was examined, not the surveyor. And if again,
that is what, no? In
yes.
the very beginning, you had said that the Kala had made the report. However, then later on now, then you are talking about the surveyor. So it is not the Kala who made the report, it is the surveyor who made the report.
Survey, yes, my lord.
Then Kala has acted upon the surveyor's report.
Yes.
That is what you should have said. You have to be careful with your choice of words. You lead us up the wrong garden path.
My lord.
You have to be very careful.
If
don't be in a hurry.
My lord.
Don't have to, it doesn't have to be, there has to be a full stop sometimes. Please. Please, when you make a submission, please ensure that it is understandable. You cannot change the words as you want.
My lord.
Kala has acted upon the report of the surveyor.
My lord.
It's not that Kala has made the report. Where is the surveyor's report? Let us see. Where is it?
Lordship, that surveyor report was not specifically mentioned in their appeal.
If your lordship will come
from page report is not mentioned?
43, my lord. If it starts from 43.
No, that is only
the assessment. This is the assessment made by the surveyor.
This is the assessment made by the surveyor?
Yes. Para 7.1. And it continues para 7.2.
In your house pass, you've got how many trees altogether? My God. How much? How many trees is this?
Actually, the appellant feels that reassessment the appellant feels that reassessment was a new development. Actually, Lordship, it is not a new development.
Mr. Counsel, I am not on that.
Yes.
How many trees are here altogether?
40.
What 40? Even this number 17 itself is 5,063 trees. And then you have got here and Southing 1,326. How are you going to count Southing? I don't know. 1,326 Southing.
Actually, that is,
And Bong Cho is 876. How do you count Bong Cho?
I don't know, Lordship, that is within specifically to the surveyor.
Phui Nam 92. Okay, that you can count.
Lordship, actually, true thing is very clear.
Mun Phia 1268.
And my lord, that it has been given in a table, and below that table, para 7.2 starts again. That is in para 7.2. It continues till page number 45. So,
where is the surveyor's report? Kala. Yes, who's appearing for Kala? No one.
Yes, Your Lordship. The information that I have received is the same one that has been submitted by the appellant, the verification report of 3rd September 2021, Your Lordship.
You have got what? The survey report.
Your Lordship, that I have not received. I only have the order dated.
Survey report is not here. Is it here? Not here.
No,
there is nowhere in the records.
Yes.
And how can look? This number 17, 5,063 trees. Where are you going to build a house? On top of the trees or something?
Actually, my lane is very vast.
Very vast.
Page number 33 there.
Page number 33.
Yes, my past is reflected there.
Page number 33. So it is not given in the village. Yeah, house side is given in the forest. Is it?
At point number 3, it was written in Mizo, but very...
Adung.
Yes.
Adung 300, Avang 250.
Yes.
So, 300 feet must be?
Yes, feet.
300 feet by 250 feet. That cannot, how much will that hold? 300 by 250. 0, 0.
Whether feet or not is...
7,500, no, 75,000 feet area.
But my lord, actually that is... that is not the issue because...
No, that is not the issue, but I just wanted to know.
Yes.
I have not heard of anyone being given a house VC, house pass, such a vast house pass area. If they've given you in the village or somewhere in the forest or somewhere, where? House pass. There is no date. There is no date. There is no date. Something is fishy out here. Anyway, if there is no survey report, he should be allowed to cross-examine. You cannot altogether. How many trees are there, Babre? 5. Probably around 8,000 trees, 7,000 trees.
Yes.
Huh?
Lordship, actually, the NHIDCL had already submitted. They had no objection before the landed arbitrator during the arbitral proceedings. And besides, my lord, when they submitted an application before.
But then you don't have the report with the surveyor's report here also.
Yes, that should be reflected by the appellant lordship actually.
What about you? It is your land. And what about Kala? Kala has got nothing. From where did you get this assessment of copse and trees?
That would be again, Your Lordship, on the basis of the report of the surveyor. That I believe, Your Lordship, that is on the basis of the report submitted by the surveyor.
You see, when earlier the crop damage was 12 lakhs, it was paid. Now suddenly another 57 lakhs.
55 lakhs plus.
55 lakhs plus.
My lord.
It's too much.
The reason is that lordship.
So they missed out.
Yes.
They missed out.
The first assessment was missed out.
They missed out around 5,000 trees. They only saw 200 trees first.
The reason
then
is that
later on they found, this 5,000 trees was hidden. We could not see it. There were too many clouds.
Actually, my lord, the reason is that assessment was conducted on 14/3/2021 and
14/3/2021. You said 14/10/2021. 14/3.
Yes, 14/3/2021. And during that day, the surveyor could not finish assessment. So
that is the first assessment.
Yes, that is the first assessment.
And the second assessment?
23/3/2021.
23/3/2021.
Yes. On the first day of assessment, when I asked the surveyor whether I need to give my signature on the assessment sheet, surveyor insisted that when I completed all the assessment, you would be given your signature.
Tell me one thing, how does he count Munpia to be 1268?
Lordship,
1268 Munpia.
If the
how do you count? You know how to, have you seen a Munpia plant?
Yes.
Do you believe it? And then how do you count Bong Cho? How do you count Bong Cho? He says 876. Bong Cho is a tree or what? Is it a crop? Is it a tree? Bong Cho. What is Bong Cho? What is it?
My lord,
what is Bong Cho? Is it a tree? Is it a crop? What is it?
I think, yes, Lordship, this is the banana.
No, that will not be, my lord, because
because
in the Tenzol,
Bong Cho is no.
Yes, in the Tenzol Veti farm, they have planted some grasses for
what is the Bong Cho? Any idea?
This will be grasses, fodders.
Fodder is fodder.
Yes.
Fodder is not
because
tree.
That is what is
Bong Cho is fodder.
Tenzol,
how do you count fodder? How can you give for Bong Cho?
All Bong Cho can also
Bong
be sold.
Cho, he says fruit bearing. how is Bong Cho fruit bearing? And he's given you, for Bong Cho, he's given you 1,97,000. First of all, what is Bong Cho? We don't know. Number two, how is this Bong Cho fruit bearing? What fruit does it bear? I don't know. This total non-application of mine. They should have been given a chance to cross-examine.
Lordship, actually, they are giving an opportunity, but they did not raise any grounds for cross-examination of that surveyor.
Okay, I'm going. Let me ask Kala. Yes, did you give them an opportunity to cross-examine the surveyor?
Your Lordship, as per page number 42, 39 of the appeal, it says that providing an opportunity of being heard and or to ascertain each point.
Providing an opportunity and in order to ascertain each point, hearing has been fixed on 5th. Thank you for helping out.
Kala is also requested to be present in hearing for providing necessary clarification.
Yes. So it's only on 5th September.
And my lord, if your lordship will come at the next page,
Just
40, member present, no surveyor.
No surveyor.
Yes, member present, only three reflected.
Lordship, actually.
Just a minute. Okay, where does it say that the second amount of 56,000 is on the basis of the surveyor's report? Where does it say that? At 57
number 43. It starts from page number 40.
No, but where does it show that the amount is on the basis of the second survey report? Where does it say that?
My lord, it starts from page number 42, para 6.
Page number?
page number 42, para 6. Reassessment, it starts from 5th line from the bottom.
As per the reassessment, what is the amount? 52 lakhs? No.
No, total it comes 55 lakhs 53,873.
52. From where do you get that figure?
My lord, in para 7.1, the total comes at 52.71.
Para
and
7.1.
Yes, para 7.1 for page 43, the table.
Ah.
Yes, the sum total of the
52,
table.
that is for the crops.
Yes, and then below it, para 7.2 from number 1, again 3 lakhs 8,000 is given, and at para 2, 3.65 is given, and para 3 for water tanky damage 2 lakhs is
and
given.
And RCC again
yes.
6.2.
Yes, so the total it adds up to 55, 53, 873.
55, 53,
873.
Yes, my lord. In the first day of assessment, if I was appending my signature in that assessment sheet, all this will be included in the 3G notification. I'm very sure, because the Kala also clearly reported that this the non-appendix.
You see the assessment of crops and trees. This has to be cross-examined. You cannot have bong cho. Bong cho is basically fodder. Bong cho is basically fodder. And fruit-bearing fodder, I've never heard of it. I don't know what fruits are borne by bong cho. What fruits do you eat? What fruits does bong cho give?
I'm sorry, Lordship, this time I cannot say.
This time you cannot say.
Yes.
Okay, right. Heard Mr. T. Lal Zakima. What is this document?
My lord, that is the first order, the initial award, my lord.
Okay, heard Mr. T. Lal Zakima, learned counsel for the appellant. Also heard Miss Lal Nunrui, learned counsel for the respondent number?
2, Your Lordship.
2. Mr.
Okay,
Lalbi Akima.
Yes.
Appears for respondent number 1. By way of the present appeal under section 37 of the Arbitration and Conciliation Act, 1996, hereinafter referred to as the Act, the appellant has put to challenge the arbitral award dated 2/12/2024, arbitral award dated 15/3/24, passed in arbitration case number NH-06/KZN/22/ARB-2023, and the order dated, impugned order dated 2/12/24, passed by the Court of the Additional District and Sessions Judge Champai in arbitration application number 4 of 2024. The matter pertains to acquisition of land for the purpose of widening and broadening of NH-06 upgradation to 2-lane with paved boulders of Dulte-Champai Road International Border under so and so in the state of Mizoram. in para 2 of the thing, page 8, para 2. Next. The appellant, for the purpose of assessment, for the purpose of payment of compensation, the respondent number 2 had issued, is it award or notification? What? Is it an award or notification?
My lord, this it's written order.
Had issued an award for compensation for the acquired lands under section 3G and 3H of the National Highways Act, 1956, hereinafter referred to as the 1956 Act. Wide letter dated 3/9/2020, wide letter number C /18019 /3/2021 DC KZL dated 3/9/2021. The respondent number 1, who was the owner of land covered by VC House Pass number 6 of 2014.
My lord. Serial number 43, my lord. 43
was awarded.
And 137.
Who was at serial number 43?
And 137.
And 137 of the list of landowners whose lands had been acquired was to be given compensation amounting to rupees 12,72,480 on the basis of a crop value. For crop value, is it? Crop value.
My lord.
For crop value, دقيقتي ان شاء الله. On the basis of crop value, on the basis of the surveyor's report dated 14/3/2021. Gustav. When was the second surveyor's report made? 7 days later.
My lord.
Correct?
My lord.
However, on a reassessment made by the surveyor on 23/3/2021.
Reassessment is lordship. Reassessment is 14/10/2021.
Oh, 14/10/2021. Yes. 14/10/2021.
My lord, if your lordship will kindly come at page number 31, that was the last and final reassessment. In the application, page number 31, in the application filed by the respondent before the arbitrator. He had stated
You see, you give a list of dates.
Yes, my lord.
List the matter tomorrow. Give a list of dates. Yalla. Give a list, a proper list of dates.
My lord.
This is the matter day after tomorrow. Day tomorrow. Day after tomorrow. Next. This.
And I'm sorry, my lord, for interrupting your lordship. My lord, item number 2, my lord, I believe the appellant has mentioned it, my lord, before your lordship, my lord, for posting it on hearing on Friday. Friday, my lord, I'm in some personal difficulty, my lord, keeps it on the Monday if possible, my lord.
Okay. That item 2.
I will inform Mr.
Okay, right.
Yes.
On the prayer made on behalf of the appellant's counsel, this is the matter on Monday.
3rd of August.
My lord, I am for the respondent, my lord. The appellant's counsel had mentioned it earlier when your lordship
on
sat.
the prayer of the counsel for the parties, this right, on the prayer of the counsel for the parties, that's all.
Yes.
Item number 3.
I'll inform the other side, my lord. I'm grateful.
Your Lordship, we have filed a adjournment request memo yesterday.
Item 4.
Item 3.
3. Right.
If
on the prayer for adjournment made on behalf of Mr. C. Zoram Chara, this is the matter.
After a week.
After a week.
Item number 4.
Obliged, Your Lordship.
Yes, what is this?
Well, it's the matter pertains to an issue that has been aroused after the arbitral award. The issue pertains to escalation of the land valuation.
Yes, who's there?
My lord, I'm for respondent number 3 and I'm on behalf of my senior conducting counsel, Jonathan Nalrin Klonga. And he said that he is indisposed of, so he couldn't appear today.
He's on behalf of Kala Millets.
Yes.
You're on behalf of Kala?
Yes.
So Kala is not necessary. Who's
Private parties are not here.
Huh?
Private parties are not here. Nobody is representing.
Why?
Basically, I mean to say they are not available today.
They are not here today?
Yes.
Otherwise they were here earlier?
Yes.
Now what to do?
May relist it on Friday if convenient.
On Friday we have already fixed this. No, too many. Right, Mr. Kartik Jain appears for the appellant. While the respondent number 3 is represented, no one appears for the respondent number 1 and 2. List the matter after 2 weeks.
Obliged, minutes.
Item number 5.
Lordship, I'm appearing for the first time for respondent numbers 1 to 4. So if I may be allowed to submit our affidavit in opposition.
Madam, you are appearing for whom? For the petitioner? What is wrong with this order? Oh, your senior is having throat problem. Huh?
Yes, my lord.
Are you sure? I heard he was laughing up a storm during lunch. Or in the morning, no. He's having problems. I don't know whether this case is maintained. Your case is under 227. Now 227 is basically the issue of whether the court has got the jurisdiction or has passed an order in excess of jurisdiction. So he has passed an order which nothing to show that it is not without jurisdiction. This is where the court has, the learned district judge has allowed the condonation, correct? You are challenging the condonation granted.
Yes, my lord.
What is wrong?
There is involvement of fraud and
There is?
forgery and fabricated signatures done by the appellant.
So that will be taken care of during the hearing. This will be taken, this is a, in the RFA it will be taken care of. I do not find any reason to allow this application, madam. Because this appeal, just CRP, not even an appeal. Okay. You might have a case. Wait. Technical defect, technical defect. I meant. No, you see, madam, the thing is, you all are saying that the earlier appeals filed had been filed by forging and fabricating the signatures of Lal Chandama and Lal Ompui. Correct?
Yes, ma'am.
But the present appeal which has been filed by this Lal Chandama and thing, so their signature is not in dispute. And if you are disputing that signature, you can go. But so those persons were not there. You all can bring out all these issues before the trial, before the appellate court. How does it matter? Why should we go into this issue? The issue here is only with regard to the delay in condoning the condonation, the delay. Once delay has been condoned, the issue of whether they had used unfair means will be decided.
My lord, condonation should not be allowed, it should be rejected.
Why?
As there is an involvement of fraud in the application.
Involvement of fraud in the petition.
Yes, my lord.
In which petition? Involvement in the filing of the application for condonation of delay.
Yes, my lord.
Okay, Mr. Yes, your name?
Loma Maralte.
Loma Maralte, appearing for the respondent number?
1 to 4, my lord.
1 to 4. Is granted 2 weeks time to file written objection. This is the matter after 2 weeks.
My lord, I respectfully pray for the extension of interim order dated 3/7.
What is the interim order?
For staying of further proceedings in RFA number 37 of 25.
Interim order to continue till the next thing.
Anyone to do hearing matter?
Any hearing matters? Anyone is ready for hearing matters? Mr. Ralshan, you be ready with your Friday. You tell your juniors because the facts are very clear. There is nothing to hide. The law is clear. The facts are clear. It's not that we have to hear you. When the pleadings, averments are there, everything is there.
I to raise my point myself.
Yeah, we'll see you Friday. Now don't go to the canteen and start laughing loudly.